Okay, today we're going to talk about a recent Delaware Supreme Court decision called Central Laborers versus News Corp. It was a recent Delaware Supreme Court decision involving Section 220 of the Delaware General Corporation Law, which involves the rights of shareholders to seek books and records of corporation. It was an appeal from a Court of Chancery decision which dismissed the claim based on the failure of the plaintiff to establish the statutory prerequisite of a proper purpose. The Court of Chancery found that the proper purpose requirement was not satisfied because simultaneously with filing the Section 220 case, or at least on the same day, the same plaintiff filed a plenary action, a derivative action against the same company seeking relief for breach of alleged fiduciary duty violations. And so the Court of Chancery determined that because a plenary derivative action was filed on the same day, the proper purpose requirement was not met, because the presumption would be that if you are filing a plenary action that you already have sufficient information to file that suit, whereas a Section 220 case, at least typically, would precede a plenary action, and the Section 220 case would be filed at least in part for the purpose of obtaining information on which a subsequent plenary derivative action would be filed. So that was the issue presented to the Delaware Supreme Court, whether or not the dismissal by the Court of Chancery was appropriate. The Delaware Supreme Court in effect punted. They affirmed the Court of Chancery decision, but on different grounds. So they never reached the issue of whether or not a proper purpose for a Section 220 case could be established if a plenary action is filed on the same day. The grounds on which the Delaware Supreme Court affirmed the Court of Chancery was based on a prerequisite that relates to the form and manner of a demand. Prior to a Section 220 lawsuit being filed, a letter demand is sent to the corporation, and the statute requires that that letter demand follow certain prerequisites. They satisfy certain prerequisites. One of the prerequisites is that if a shareholder is a beneficial owner, that proof of beneficial ownership be attached to the demand letter. In this case, that requirement was not met. The proof of beneficial ownership was not attached to the demand letter, and although it was subsequently submitted after the lawsuit was filed, a motion to dismiss was filed to the Section 220 action. And in response to that motion to dismiss, they said, okay, well, here is the proof of beneficial ownership that we should have attached, but now that you have it, everything should be okay. Well, the Delaware Supreme Court did not agree. Delaware Supreme Court said the statutory prerequisite of attaching a proof of beneficial ownership is a requirement that will be strictly enforced and cannot be satisfied by subsequent remediation, and therefore on that basis the court dismissed the Section 220 action because the statutory prerequisites were not followed. So the plaintiff then has nothing to show for all of its litigation efforts, and it took about a year or so to get to this point, because after the Court of Chancery decision, it was not an expedited appeal, although there are some expedited Supreme Court appeals that are decided within mere weeks of the Chancery Court decision. This was not expedited, but still the plaintiff spent a considerable amount of money litigating in two different courts with nothing to show for it. So that might be an example of how Section 220 is not always as simple as it may appear in terms of a plaintiff seeking books and records. And as my learned colleague Kevin Brady mentioned on another video cast on LexisNexis, he and I co-authored an article recently that was published in the Law Review this month, the Delaware Journal of Corporate Law, on Section 220 issues, and in particular how the right to books and records relates to electronically stored information, or ESI. And anyone interested in a more detailed discussion of that might want to review the Law Review article that came out on that issue. Thank you very much.